Welcome back. In the last video, we were talking about computer-generated evidence. In the video, we defined what a computer is. We also defined what computer-generated evidence is. Then we classified it properly so that we would be able to tender it in court. Then we talked about the civil case of Ukonji and Njonkama, which sets the criteria for admitting computer-generated evidence in court, which is that the document must be pleaded, it must be relevant to the fact in issue, and it must be in admissible form prescribed by the Evidenceact. For criminal cases, we said that while Ukonji and Njonkama is a civil case, that the principle can still be applied, but with caution. We also talked about the relevant sections of the Evidenceact 2011, such as Section 4 to Section 13 and Section 84 for admissibility in terms of admissible form. We also talked about proceeding with caution while applying the Ukonji and Njonkama case to criminal cases. If you haven't watched the first video, I highly recommend you go watch that first before you come watch this one, as it will give you a better understanding of what computer-generated evidence is, before we go ahead and dissect Section 84 of the Evidenceact proper. Here we go. This simply states that if a statement would be admissible in court if made by a live witness, then it would also be admissible as a computer-generated document, provided that certain conditions laid out in Section 84 subsection 2 are met. And now we're here, the moment we've all been waiting for. You've read it and it has confused you so much. Have no fear, I've come to save you from your worries. I'll start with some good news. You don't have to cram these conditions. You just need to understand them and then you can apply them to anything. For context, I'll read the conditions one by one and then I'll give a simplified version of each, and then we'll apply that version to real life situations so that you'll be able to remember. So this is the boring version. A. That the document containing the statement was produced by the computer during a period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period, whether for profit or not, by anybody, whether corporate or not, or by any individual. Simplified version. A. That the document was produced over a period when the computer was regularly used. Boring version. B. That over that period there was regularly supplied to the computer in the ordinary course of those activities information of the kind contained in the statement or of the kind from which the information so contained is derived. Simple version. B. Over the relevant period, similar information alongside the one we want to tender was regularly supplied to the computer. Boring version. C. That throughout the material part of that period, the computer was operating properly, or, if not, that in any respect in which it was not operating properly, or was out of operation during that part of that period, was not such as to affect the production of the document or the accuracy of its content. And, simplified version. C. Throughout the relevant period, the computer was operating properly. And, boring version. D. That the information contained in the statement reproduces or is derived from information supplied to the computer in the ordinary course of those activities. Simplified version. D. The information you want to tender as evidence derives from information supplied to the computer in the ordinary course of those activities then being carried out. You see how easy that was? The wordings in this Evidenceact are just crazy. Like it could have been easier and just saved everybody a lot of stress. I blame the draftsman. Now that I've actually compared them side by side, I'll just list the simplified version one more time. So the conditions are as follows. A. The document was produced over a period when the computer was regularly used. B. Over the relevant period, similar information alongside the one we want to tender was regularly supplied to the computer. C. Throughout the relevant period, the computer was operating properly. And D. The information you want to tender as evidence derives from information supplied to the computer in the ordinary course of the activities then being carried out. Now this is a more simplified version, but to help you understand it better, let's apply these conditions to two different computers to illustrate. So let's take a video footage from a CCTV camera. For this footage to be admissible, 1. We have to ensure that the video was produced over a period when the CCTV camera was regularly used. In this case, for 24-hour surveillance. 2. If we wanted to tender 5 minutes of the video footage as evidence, then we have to make sure that similar surveillance footage was stored for a relevant period of time, i.e., the remaining 23 hours and 55 minutes surrounding the 5-minute video footage we need. I believe that this helps the court ensure that the evidence wasn't fabricated specifically for the proceedings, but that it was actually evidence that the camera captured in the ordinary course of business. 3. We have to make sure that throughout the relevant period, the CCTV camera was working properly, or at least the part that stores and processes information was working properly. 4. Lastly, we have to make sure the 5-minute video footage we want to tender derives from information that was supplied to that particular CCTV camera. Let's try to apply these conditions again, but this time with a video recording of a Zoom meeting. 1. We have to make sure that the video was recorded on a laptop over a period when it was regularly used, in this case, for scheduled Zoom meetings. 2. If we wanted to tender 2 minutes of the 1-hour video recording of the Zoom meeting as evidence, then we have to make sure that similar surveillance footage was stored for a relevant period of time, i.e., the remaining 58 minutes surrounding the 2-minute video footage we want to tender. 3. We have to make sure that throughout the relevant period, the laptop was working properly, or at least the part that stores and processes information was working properly. In this instance, it's possible that the computer may not have been functioning properly due to a lack of software updates. But as long as the central processing unit, the CPU, the part of the laptop that stores and processes information is working properly, the condition will be met. 4. Lastly, we have to make sure the 2-minute video recording of the meeting we want to tender derives from information that was supplied to that particular laptop. That ensures that the footage was recorded live and at the relevant time. Any other footage not recorded live or with that particular laptop would carry with it a rebuttable presumption of fabrication. Now I'm going to do something unorthodox. I'm going to give you homework. You're going to take section 84 sub 2 and apply them to the following documents: a voice recording from an audio recorder, a video footage from a drone, a screenshot of a text message from a smartphone, a picture from a DVD. Make sure you practice with these so that you'll get familiar with the conditions. If you've been paying attention, we've been talking about electronically generated evidence from one computer at a relevant period of time. But what if there were multiple computers storing information at that relevant period of time? For example, what if there were 3 CCTV cameras installed in a room covering the same area, but they weren't meant to operate simultaneously, and they were to take turns to capture footage? The Evidenceact actually envisages something like this, and that's why we have section 84 sub 3. This ensures that in such an instance, evidence generated by a combination of computers or by different computers operating in succession can still be admissible. This ensures that in such an instance, evidence generated by a combination of computers or by different computers operating in succession can still be admissible as long as it was obtained in the relevant period of time. Section 84 sub 5 is just definition subsection. You can reference that on your own later. It's pretty short. Evidence Amendment Act 2023. Sections 2 and 3 of that act amend the principal legislation, which is the Evidence Act 2011, and includes electronic records as a type of computer-generated evidence. It also talks about the digital signature that is affixed to the electronic record. Now that we've gone through everything, we have to tie them all together with a nice little bow. There is one more thing to do to ensure that the evidence is in admissible form, and that is laying proper foundation before we can tender it. We do this by accompanying the evidence with a certificate of compliance made and deposed to by the operator of the computer. The operator of the computer will identify the document and how it was produced, with particulars of the computer used to produce it. Finally, the operator will certify that the conditions laid out in section 84 subsection 2 have been duly complied with. An authority you can rely on for this is the case of Kubo and Dixon. Let me give you an illustration of this requirement. For example, if the computer-generated evidence was video footage from a CCTV like earlier, then the operator of the CCTV camera will have to depose to a certificate stating the following facts. 1. that the document containing the statement is a video footage captured by one of our CCTV cameras. 2. That the CCTV footage is stored in a digital format on a digital video recorder, DVR, that converts analog video signals to digital format and stores them on a hard drive. The stored information includes stills, video footage, metadata that contains dates and timestamps, camera ID and location, motion detection data, and V-access logs. The footage is stored in a compressed H.264 format to reduce storage requirements. 3. That all the conditions listed in Section 84 Sub 2 of the Evidence Act 2011 have been duly complied with. In practice, when you want to draft your statement of compliance, you can always use the language provided in the Evidence Act. Again, you don't have to cram these, just understand them. If you can get this certificate of compliance alongside the criteria for documents to be admissible, then the court will not only admit your computer-generated evidence, but will rely on it because of its strong probative value. Thank you very much for watching my video. If you like what you just watched now, please like, subscribe, and share with your friends. Also, please feel free to hit the notification bell so that you get updates when my videos come out. Engaging with the content actually helps the algorithm see my videos, so I get to share it with more people. So I'm very glad you watched and you stayed with me. We keep growing from here. Don't worry, we'll be getting more content like this. Have a great day.